Good evening, everyone. Welcome to our panel discussion, Israel before the Hague Courts, the role of international law in the Israeli-Palestinian conflict. I'm delighted to see so many people tonight. I think that underscores the importance of tonight's event and topic. My name is Miriam Heipertz. I'm a PhD researcher in international and European law at Amsterdam University. And it is my privilege to moderate the discussions tonight. Let me begin by thanking Professor Jolande Jansen, who is sitting here in the audience. She organized the event. And also thanking SPAU 25, which is always a great space for bringing academic debates to a broader audience. Tonight, we are joined by three distinguished speakers. Dr. Nima Soltani, reader in public law at SOAS University of London and editor-in-chief of the Palestine Yearbook of International Law. Dr. Soltani will unpack for us the ICJ's advisory opinion on the legality of Israel's presence in the occupied Palestinian territories and the broader implications of the South Africa case before the ICJ against Israel. Next, we have Professor Sergei Vassiliev, Professor of International Law at the Open University, Netherlands, and an expert in international criminal law, who will guide us through the ICC's ongoing investigations into alleged crimes in Palestine. And last but not least, Professor Janne Nijman, Professor of International Law at the University of Amsterdam and the Graduate Institute in Geneva, and member of the Advisory Council on International Affairs, an independent body that advises the Dutch government on foreign policy and Parliament on foreign policy. A broader audience might know Professor Nijman from a recent op-ed published in NRC on Dutch responsibilities in response to the ICJ advisory opinion of July this year, a topic that she will address in her intervention. So, the program of tonight is that each speaker will present for 10 minutes, followed by a 20 to 30 minutes panel discussion, and then we'll open up the space for a Q&A. So please keep your thoughts and questions in mind as you listen. Now, this is a sensitive topic, especially given recent events in Amsterdam and around the world. But tonight we hope to create a space for understanding and reflection on how international law addresses the Israeli-Palestinian conflict. And while the issue might evoke strong emotions, I would ask you to try and engage in this discussion with respect and shared commitment to dialogue. Okay, so I also imagine that in this audience there are not only lawyers, but a broad audience, at least that's what I hope. And law, let's begin by acknowledging that law and international law in particular can sometimes feel abstract, jargony, and quite technical. So we'll do our utmost to break it down, break these concepts down, and show how they actually can help us understand the current situation. Some general background, and this is the start of trying to break down the current, the legal world for you. We'll draw on three important legal proceedings as reference points: two situations before the International Court of Justice and one situation before the International Criminal Court. So it's helpful to know that these are two distinct institutions, both based in The Hague. But with very different purposes. There's the International Court of Justice, also called the World Court, which handles disputes between countries and gives legal advice on questions of international law, for instance, to bodies of the UN, such as the UN General Assembly. But it does not prosecute individuals. On the other hand, we have the International Criminal Court, which does investigate individuals, leaders, officials, or other for the most serious international crimes like war crimes, crimes against humanity, genocide, and crimes of aggression. Now, the three proceedings that we are going to draw upon in our discussion are the ICJ advisory opinion that was delivered on July this year, which found Israel's continued presence in the occupied territories unlawful, raising questions about the obligations of other states under international law, such as the Netherlands, in response to this situation. Then there is the second case before the ICJ, that is the South Africa case against Israel. In this case, South Africa accuses Israel of failing to prevent genocide in Gaza. This case is still ongoing. And then we have the ICC investigations into Palestine, which examine alleged war crimes and crimes against humanity committed in the Palestinian territories. And this investigation focuses on individual accountability of all parties, Israel and Hamas. With that general introduction, let's begin. Nimer, may I invite you to take the floor.
Thank you very much, Mariam, for inviting us and for organizing, and thank you for the host institution. Good evening, everyone. Thank you all for being here. I guess I'll try to address as briefly as I can the question of how the two ICJ cases on the genocide and the legality of the occupation in July disrupt the Western mainstream narrative about Israel and Israel's genocide against the Palestinians since October. As you all know, within less than a week of the Israeli attack on Gaza, experts said that the amount of bombs inflicted on Gaza in less than a week was greater than the bombs inflicted on Afghanistan, a much bigger country and less dense relatively, in a year by the United States. Within 3 weeks, we were told that the equivalent of 2 Hiroshima bombs were inflicted on Gaza. By the end of October, Oxfam said that the number of children killed in Gaza was more than all the children killed in conflict since 2019. Also, by the end of October, the children said that, and Oxfam said that Israel is using starvation as a method of warfare. In November, UN officials started talking about the war on children and the war on childhood. In December, Human Rights Watch talked about starvation as a method of warfare by the Israelis, as well as a war crime. In January, UN officials started talking about Gaza as unlivable, uninhabitable, given the amount of destruction that was imposed on Gaza. By June, we are talking about around 70,000 tons of bombs dropped on Gaza, which is twice more than what the Allies and the Germans dropped on Dresden, Hamburg, and London combined. So the amount of destruction was quite unprecedented. The number of people killed in Gaza by August, over 40,000, which is, as everyone realizes, underreporting, is more than the number of people killed in the Myanmar genocide against the Rohingya. The death rate, the killing rate, the monthly killing rate in Gaza surpasses that of the Bosnian genocide in the early 1990s. The killing of 2% of the population by August also is a quicker pace of killing than other recent conflicts, such as in Syria. So the number of people killed, or the percentage of the population, were killed with a shorter period of time. About 70% of the homes and residential buildings were destroyed. 70% were destroyed in Gaza in this period. About 10% of the population were either killed or maimed or disappeared. Now, imagine 70% of the Netherlands destroyed. Imagine 10% of the population killed or maimed or destroyed. Wouldn't you call this a genocide? The Netherlands and 6 other states, and 5 other states, including France, Germany, and the UK, Denmark, and Canada, submitted on 15th of November a declaration of intervention in the Gambia case versus Myanmar, in which they said we should not have a narrow construction of the Genocide Convention, because if the threshold is too high, then there will be no judicial recognition of any cases of genocide. And in particular, they said the killing of children on a large scale evidences genocidal intent. The number of children killed, if we apply the same logic to the question of Gaza, the case of Gaza, we're talking about above 17,000 children killed. More are under the rubble. We're talking about 17,000 more who are without amputated, 20,000 who are orphaned. So these 6 states in the Gambia case said, killing children on this scale precludes other defenses or explanations, such as that there is a security or a military goal. So it has to be considered as a genocide, even if the state invokes. And we need also to remember that Myanmar said something similar like Israel. There was an attack on Myanmar in October in 2016, another attack in 2018 by Rohingya armed elements. Does that mean that this is a war rather than a genocide or a genocidal war? They also said it's complex. And they also said we have an independent judiciary, etc., and that only individual cases will be tried. All these things were not convincing in the case of Myanmar and its genocide against the Rohingya. And most Western states recognize the genocide against the Rohingya as a genocide. But when it comes to Israel, we see a different treatment. At the end of May, the 29th of May, 2024, South Africa submitted to the United Nations Security Council 120 pages dossier of a documentation of incitement to genocide, genocidal intent, and expressions of contempt for the ICJ and its orders. So there is a lot of evidence, both for genocidal acts in terms of killing, in terms of the infliction of bodily harm and mental harm on the population, including children. One UN committee recently, the UN Commission of Inquiry, said 70% of those killed between October and the 30th of April are women and children. And of course, there are also innocent men that we need to add to that. The same committee also released a report about the systematic destruction of hospitals in Gaza. So what we see here is a systematic destruction of the population, everything that sustains life. And we saw many doctors who volunteered and went to Gaza who came back with the same kind of conclusion, that this is not a war, but this is an elimination. This is a decimation. And that they witnessed many cases of children being shot by snipers in the head. So all of this is to say that the threshold between a war in which one side tries to defeat the enemy and a genocide in which there is a logic of elimination has been crossed. And this should be recognized as such, and yet we don't see many states in the West who do that. So hence the importance of the ICJ case. When South Africa went to the ICJ in the end of December, it gave a frame and a comprehensive account of what Israel has been doing since October and what they said they would do. They said they are going to cut water, electricity, and medicine. When the Russians said that and did that against Ukraine a year before, the representatives of the EU said this is a pure act of terror. When Israel did it, they went and took pictures with the Israelis and expressed support for their so-called war of self-defense. The orders in January and then in May and then in March and then in May said there is a risk of genocide unfolding in Palestine, in Gaza. and that each country in the world that is a party to the Genocide Convention has a duty to prevent genocide in every way they can. And obviously, what we see since then, that there is a failure by states, specifically powerful states that have the capacity to influence Israel, to discharge this obligation to prevent. In fact, they are complicit in the genocide because they keep supplying Israel with arms, political and diplomatic support. So that frame of a genocide, as opposed to simply a war, a tragic war, and messy things happen in war, is important to remember. And we owe that to the ICJ case because it gave support to the student movements, to the lawyers in domestic litigation who wanted to pursue accountability for their own domestic state governments that were complicit in the genocide. It was also important to show that the media, the Western media, and the wall-to-wall support for the genocidal war was misguided, misconceived, and in fact criminal. Now, fast forward in July. July, when the advisory opinion by the International Court of Justice also is delivered, what we see here is that the whole context that we were told about the October the 7th is explained in a much more accurate way. So what the Western narrative and the pro-Israeli narrative is that Israel was surprisingly attacked by a cross-border raid. But what the ICJ tells us in the advisory opinion that the West Bank and Gaza are occupied territories. And the International Court of Justice already said in 2004 that the concept of self-defense as part of the UN Charter does not apply to cases in which Israel or a state like Israel exercises effective control over a particular territory. So when the attack comes from that territory, this is a situation of occupation and apartheid, as also the International Court of Justice said in July. So the fact that Gaza was occupied, the fact that Gaza was under siege for over 16 years before October 7th, which is something that South Africa, in its application in December, paid attention to and highlighted. The fact that there is an illegal occupation for over 56 years prior to the October 7th, the fact that there is an ongoing ethnic cleansing or Nakba since 1948, these were erased from the narrative. And then the International Court of Justice in July said that these are things that we need to keep in mind. In fact, the court said the occupation since 1967 is an ongoing situation of aggression against the occupied, against the Palestinians inside the West Bank and Gaza. And you can't simply discard millions of Palestinians behind a siege and a blockade in Gaza and annex East Jerusalem without any consequences or any accountability as per international law. The one last thing that I would say about the importance of the case is that it also shows that all these arguments of security that Israel has been invoking in order to justify its long-term occupation are not compelling and should be rejected. So the ICJ refutes that by telling us that security does not justify apartheid or discrimination. Security does not justify permanent forcible transfer. Security does not justify annexation. Security does not justify long-term denial of self-determination. So all these arguments that Israel invoked and now invoking to say we object to the establishment of a Palestinian state are not compelling and should be rejected. The final concluding remark is to say this. What we see since these two ICJ cases and the reaction by the Israeli government and its allies is throwing the international legal order into an existential crisis. Palestine has always been a litmus test to the international legal order, and it's even more so today. By litmus test, I mean Palestine is not an exception, but rather it is the test that shows whether really human rights are universal, whether the law is applicable to everyone equally, or whether there are rogue states, outlaw states that are above the law and might make right according to them rather than play by the rules like everyone else. Thank you so much.
Thank you, Nima, for this powerful intervention. Sergei is going to enlighten us now on the ICC situation. Thank you.
Yeah, thank you so much to the organizers for having me. I was very happy to be able to jump on this bandwagon in the last minute. So I was asked to address the situation of the state of Palestine, Israel and Israeli leadership before the International Criminal Court. And I think I will pick it up where Nimir stopped his presentation, namely that this situation will actually be a litmus test and a real test case for the legitimacy of international criminal justice as a project, and also a matter of legitimacy for the International Criminal Court as the flagship of international criminal law. So it could actually become that final nail that is driven into the coffin of international criminal law and its emancipatory function that victims tend to attribute to the courts in The Hague. Because I think the treatment which the Palestine situation has received so far at the ICC is quite demonstrative of the difficulties and challenges that the Palestinian people are facing when trying to obtain justice and to ensure the realization of their rights under international law elsewhere. So will international criminal law stand this test or not? We're yet to see how this will end. But just to walk you through the timeline very quickly, it took the ICC about 12 years to just open an investigation into the situation in the state of Palestine since the first attempt by Palestine to engage the ICC in the ongoing mass atrocity situation there. It took 3 further years and the aftermath of the attack of 7 October 2023 for the prosecutor to request first arrest warrants from the pretrial chamber. So that's quite a while, and much has happened in between. The state of Palestine had to gain the non-member observer status at the United Nations General Assembly. Only then they could recognize the jurisdiction of the ICC, become a party to the ICC statute. In 2019, prosecutor reached a decision that the statutory requirements for opening the investigation were met, but even then they wanted to make sure that the situation stands on a firm ground before the ICC, so the prosecutor requested pretrial chamber to confirm that the court has jurisdiction in this situation and that the pretrial chamber affirms what the scope of that situation was. In 2021, the court decided that indeed it had jurisdiction in this situation, and the territorial jurisdiction extended to the Gaza Strip as well as the West Bank, including East Jerusalem. So that's quite a lengthy trajectory already. And as for the arrest warrants, they were requested by the prosecutor on the 20 May 2024, so 6 months ago, and they were preceded by rumors circulating on Israeli media that the warrants may be coming or that they're in the process of being requested. Benjamin Netanyahu even had to make several threatening video statements about this, warning the ICC not to make the mistake. United Nations senators also chimed in and warned the prosecutor in a very menacing letter not to even think about it because the sanctions would follow. And then they concluded this letter by saying, "You've been warned." which is quite a strong statement, and it might actually amount to the offense against administration of justice by the ICC under Article 70 of its statute. Then when the warrants were issued, President Biden and Blinken, they expressed outrage. United States senators threatened the court with Trump-like sanctions. The House of Representatives passed the Illegitimate Court Counteraction Act, even that would become the basis for future sanctions against the court. And only 1 week after the requests by the prosecutor, The Guardian and several other outlets came out with a major expose which showed that in the course of past 10 years, the ICC Office of the Prosecutor was actually being interfered with, was victim of a large-scale campaign of harassment and interference by state actors, namely by the State of Israel. For example, Mossad chef Yossi Cohen essentially stalked the second prosecutor of the ICC, Fatou Bensouda, in New York at United Nations General Assembly, where he was trying to explain to her that certain moves would not be very good for her career and that she should have allowed him to protect her in a way. Then people turned up at her residence in The Hague with an envelope full of cash and a note with an Israeli phone number written on it. It was never established who those people were. Then The Guardian also made a revelation that the ICC personnel and the offices of the ICC, namely Office of the Prosecutor, were being surveyed, so their communications were intercepted by Israeli secret services, by Shin Bet, Amman, and by the Cyber Intelligence Division Unit 8200. So all this alleged facts may actually amount to the offenses against the administration of justice that must be prosecutable under the domestic law of all states parties to the International Criminal Court. And this particular country where we happen to be right now, the Netherlands, is a host state of the ICC, and it has a special responsibility to protect the ICC and its personnel and all people who cooperate with it, so that they can do their job without any interference, right? For strange reason, no criminal investigation was opened since the 28th of May, when the revelations were published, up till now. And it even took a Dutch lawyer, to file a criminal complaint with the Openbaar Ministerie, with the Public Prosecution Service, to urge them to start investigating these cases of interference with the ICC justice. So they're still waiting for the response from the Public Prosecution Service. You know, when 20 May happened, when the announcement was made, I was celebrating in the street. I thought, okay, now it's really over. The prosecutor got them. Now we'll get a judicial decision very soon. Ultimately, it took the ICC pretrial chamber only 3 weeks to issue an arrest warrant against Vladimir Vladimirovich and his children's rights ombudswoman, Maria Lvova Belova. It's another situation I've been working on very intensely over the past years. So it's a matter of 8 to 12 weeks, maybe, I thought, that the ICC would issue arrest warrants, possibly against Benjamin Netanyahu and Yoav Gallant, so the Prime Minister and Defense Minister, now former Defense Minister of Israel. But then strange things started happening at the ICC. First of all, the United Kingdom in the summer submitted a request to file an amicus curiae submission, a friend of the court submission, in which they wanted to argue that the Oslo Accords actually may preclude the exercise of jurisdiction by the ICC over Israeli nationals, because the Palestinian Authority transferred its criminal jurisdiction, or delegated its criminal jurisdiction, to the state of Israel when it comes to Israeli nationals. Of course, this argument is not convincing at all. It would not have helped in any way in the consideration of the matter, because back in 2021, the pretrial chamber has already established it had jurisdiction. And nevertheless, the pretrial chamber very strangely allowed a whole bunch of totally nonsensical amicus briefs to be submitted from most random people ever. I'm not only referring to academics, we're obviously very random, especially on time, from time to time, but there were also universities, there were non-governmental organizations, there was the United States of America, which has little to do with the ICC, it's not even a state party. There was even a United States senator submitting this amicus curiae brief. I mean, what does Lindsey Graham have to do with the ICC? Don't ask me, but nevertheless, the ICC departed from its previous jurisprudence, bent over backwards to allow all those submissions, adding work to everyone involved in this case, including to the judges themselves. It's like over 600 extra pages to read. Those submissions, they were repetitive. They didn't really contribute anything, I think, to the consideration of the case. And it contributed to the delay. So that's one of the reasons why we're still at the point when we're waiting and waiting and waiting for the decision on arrest warrants. Then in September, Israel filed very strange challenges to jurisdiction, which was very belated and also filed under inexplicable legal titles or grounds. They, for example, argued that they should have been notified about the current scope of investigation in the situation in Palestine, which got extended after the attack of 7 October 2023, in order to be able to request a deferral from the prosecutor so that they could investigate those crimes themselves. It's like, yes, that's very, very valid objection. I can't imagine Israel starting the investigation into the conduct of Netanyahu and Yoav Gallant, but nevertheless, this happened. Yes, I know I'm well over my time, but just one more thing I wanted to say. Resignation of the presiding judge, Motok. Most recently, she suddenly stepped down, explaining this by health reasons and the need to ensure the integrity of the administration of justice. Not very clear. So they got her replaced with a Slovenian judge. And then the next thing we hear is that Israel is digging for information from the pretrial chamber on Judge Betty Hölle, because she had a role in the office of the prosecutor previously, and they wanted to know what exactly she was doing there. Maybe she was involved in the Palestine situation. So it seems that they want to maybe harass all judges out of service. And then the last cherry on top of cake, the sexual misconduct allegations against prosecutor Karim Khan. So there was a very small Twitter account spreading this information that this is going on. Then United States senators chimed in as well. They said, oh, well, then the investigation in the situation in Palestine and this arrest warrant procedure has to be stopped immediately because we have this prosecutor against whom such allegations are being made. And of course, I agree that any such serious allegations need to be investigated properly. But the problem is that normally the independent oversight mechanism would do that. But the Assembly of States Parties now decided that it would be outsourced to an external ad hoc body, and that they would make sure that all the safeguards of due process are provided, and that the experts or investigators would also be independent. Do I 100% buy this? Can I trust this 100%? I'm not so sure. So my conclusion is that, as I mentioned previously, this situation is a real test case for the legitimacy, credibility, authority of the ICC. It's a question of whether or not the court would simply pursue its mandate or whether it would bow to maybe the interests of some powerful states and their allies. I also don't see a real difference between the actor called the State of Israel and the actors called Benjamin Netanyahu and Yoav Gallant. It seems that State of Israel is simply performing the role of defense counsel of these two individuals, which is exactly what they wanted, because they especially Netanyahu was always saying this is an attack against the democratic country. You cannot state that there is this false equivalence between Hamas and the leaders of the democratic state. But this is a pure manipulation, I think. So I look forward to discussing all these issues with you in Q&A. Thank you.
Okay, thank you so much. It's a real pleasure and honor to be here with you all to discuss these three legal situations, and in particular to be here with two very esteemed colleagues to do this. So grateful for the opportunity, Yolanda, Miriam, to be here. It doesn't sound... Yeah? Okay, so... I've been assigned to talk about the third state implications, the implications for third states of these three cases or situations or procedures. Now, Miriam introduced me by saying that I wrote that little op-ed in NRC, and that was really an attempt to call on the Dutch government, parliament, but also us as citizens, to take note of, in particular, the advisory opinion that Nimi already talked about. And I was surprised. I mean, the advisory opinion was given on the 19th, and I've been waiting during the summer, and nothing came. And the message of the court for, in my understanding, the Dutch government, was a need for change. And I want to talk a bit about that. So it's about third states obligations. And when I talk about the Netherlands, I, in a way, also talk about the EU at large. And I promised Miriam to mention that. So noted. So when the ICJ had given its opinion, the government remained silent, and the Minister of Foreign Affairs said basically nothing. Well, the previous Minister of the Minister of Foreign Affairs, sorry, I'm skipping a bit to tune to previous speakers, had actually, Hanke Bruins-Slot had actually responded on the same day in January 2024 to the ICJ order in the South Africa case that was just discussed, so the case on the violation of the Genocide Convention in the Gaza Strip. And it stated not just that Israel was bound by the findings of the court, but it also stated that the government at the time, that the Netherlands will respect the ICJ order and have it guide its bilateral relations with Israel. So that was a firm recognition of its duty to prevent genocide. So that was January. And one may ask whether this has happened in any case actively. So a recognition of the Dutch obligation to prevent genocide. Well, waiting for a response after July 19th by the Dutch government, I'm still waiting, and I think all of us are still waiting. So there was a brief mention of the advisory opinion and the fact that it invited the Dutch government to reflect on whether a change in policy was needed. I think that's where we need to go when we want to take this one step further. I'm going to skip a couple of things as discussed. I think it would be interesting for me to also include in my discussion of these proceedings, and in particular the advisory opinion, the advice of the Advisory Council for International Affairs that Miriam also mentioned, because you have my personal professional opinion with respect to the advisory opinion and its implications for the Netherlands. But obviously, when the Council unanimously advises something to the government, maybe that has a bit more impact. I'm not sure, but I hope so. So you learned from Nima the conclusions of the ICJ in its advisory opinion. And it says that Israel violates international law. It violates international humanitarian law, international human rights law, the Palestinian right to self-determination, the law of occupation. You're not allowed to cut off water, electricity, food. All of these are clearly well described. The OPT, the prolonged occupation, is illegal. Now, as I said, we are still waiting for a substantive response to that advisory opinion. In the meantime, in October, on October 23rd, the advisory, now it becomes a bit confusing, so the advice of the Advisory Council for International Affairs gave an advice which is entitled, so it's unsolicited advice, and as Miriam was saying, it's a very independent council, and it delivered an advice entitled Towards a New Direction for the Netherlands in the Israeli-Palestinian Conflict. Now, in this advice, and that's also what the title suggests, it calls on the government, and Parliament has a role in that, and we, as citizens, to adopt a fundamental new course in its policy regarding the Israeli-Palestinian conflict. And it has a very strong message on international law, I must say. It's very central to that advice. It has a full chapter, and it has presence in various recommendations. Now, I want to say what the implications for third states like the Netherlands are, and EU, through the recommendations of that advice. So I give it a bit of context, and what we do in that advice is say, mind you, there has been for decades a situation of looking away. That's a quote. Another quote is the recognition of negligence in demanding compliance with international law in states, and that this new course, is urgent and necessary. Now, what do we ask from the government? What do we advise the government then in terms of its new course? And for now, it may sound a bit abstract, but in the end, maybe, or during the discussion, I will show it's very relevant even to the news today, right? We saw how Wilders allegedly plans to go to visit settlers. We saw the government's response. There's something to be said there. But I want to, excuse me, want to contextualize a little bit. So when you call for the government to change its course, it has to be embedded in a few more features. The advice, and it builds on international legal obligations of a state like the Netherlands, is to put much more pressure and diplomacy to itself comply with international law, but also for Israel, obviously, first and foremost, to comply with its obligations in international law. So the Netherlands can't just do nothing, can't just continue looking away like it has been doing for quite some time. So there are a couple of overarching policy recommendations that I won't mention all here, but just to say that there is an urgent call on EU and Dutch government to use all available instruments, that is positive and negative, to pressure Israel. And today again, we saw Josep Borrell talk about the need to ban import from occupied Palestinian territory. And you could say, why has this not been happening earlier? And again, the previous government called for it, but also there it was rather late. So I'm not, I'm arguing that this is all extremely slow response, while international law is clear for a very, very long time. Not just with the advisory opinion of 19th of July, but if you look at the wall opinion 20 years ago. And even when you talk about apartheid, I'm not sure it's so clear in this opinion. We can talk a little bit about that because we can't agree to everything, so we should organize a bit of a debate. But even if you look at the Special Rapporteur John Dugard in 2003, he provided the UN with all the information and the qualification of the situation as apartheid. So it's there for a very long time, and that's why we've been saying the Netherlands is looking away, is negligent, and is becoming complicit. So I mentioned the EU Association Agreement as an example of where action is due. So generally, we advised to comply consistently with international law and the obligations arising from it, and also to encourage other states and non-governmental entities to do the same. And I guess we can talk about that a bit more. Now, in particular, there's the argument that the government should advocate, both at home and abroad, for compliance with these obligations. Now, if we then look at the particularities of these obligations, it says very specifically that a country like the Netherlands is under a duty not to recognize the situation that is termed by the court as illegal, right? So the occupation, prolonged occupation, is termed illegal. That has already been discussed, but just to remind ourselves. And so, as a third state, the Netherlands is obliged to make sure that it does not recognize that situation, nor that it aids or assists in the prolongment, the continuation of that situation. And the situation, as you may have read, needs to be ended. The situation is the prolonged occupation that is unlawful, has to be ended September 2025. So that requires action. So the third states, are demanded, instructed to act, and also to collaborate in the context of the UN and initiate peace projects. Now, if you look at the settlement policy, yes, I have to conclude, the settlement policies and practices, that should not be recognized, but there shouldn't also be any collaboration there. Now, again, what does this mean in terms of measures? So then easily you come to economic collaboration, right? And financial restrictions that are necessary. So the court is actually very clear in the last paragraphs about this duty for the Netherlands not to recognize, not to aid, not to abet. And then based on that, we can start thinking what that requires of a state like the Netherlands. And I suppose we'll talk a bit more about that. And I won't talk about Wilders now, because then Miriam gets angry. I just want to say that one of the other recommendations, that is conclusions that we drew from the advisory opinion, is that the Netherlands should recognize Palestine as soon as possible. And that's also a new course, if you want to say that, in terms of the title, or with the words of the title, of, because the Netherlands has always said that it's the end of a peace process, the recognition of Palestine. And also drawing that advice, that recommendation from the advisory opinion, the argument is made that that should be right now to make sure that the two-state solution remains on the table. I'm going.
Okay, thank you so much. I promise I won't get angry. We have, I think, about 20 minutes for a discussion, and then we'll open up for a Q&A. I'd like to, before we go into the, the discussion on apartheid, I'd like maybe to ask a couple of clarification questions. Arising from my reading of German and, well, I'm German, but German news and Dutch news, and also statements by governments in relation to whether or not the ICG advisory opinion actually has to be taken into consideration. After all, it's only an advice. Could somebody clarify? Niemer, Janne.
Thank you. Yes. Maybe I just speak loudly. Is that okay? So obviously that's part of the Dutch political scene says that the advisory opinion is only an advisory opinion. As most of us would say, it's given by the World Court, as you called it, Miriam, and it's considered a weighty and authoritative opinion and statement, so to say, by the World Court. And as such, also a state like the Netherlands has always considered the conclusions on the state of the law in such an advisory opinion as something to comply with, as to be guided by. So it wouldn't be an easy argument here in the Netherlands, I'm not sure in Germany, but to say, oops, it's not relevant for conduct of the Dutch state.
Yet we have governments saying that while they respect the International Court, they cannot respect this particular advisory opinion. So maybe we can then move on to discussing this particular case as a litmus test of the international law.
I just wanted to react to your question as well. Maybe I will sound too German now, but for me it is a question of purity of moral commitment to law. So the advisory opinion simply ascertains the status of the law that has to be complied with by states. Not only because it is set out in an advisory opinion or in any specific source, but this is simply the authoritative statement of international law as it exists. So then the states must, at least those of them that claim that they respect international law, regardless of the source, they must simply comply with it. But again, this is about the category that we call international rule of law rather than rules-based international order, which is a transatlantic invention, I think, which is supposed to surrogate the very simple notion of international law. I think John Dugard made a very compelling critique in an editorial in Leiden journal about this. So do states simply respect international law because they feel bound by it, because they regard themselves as bound by the rule of law, or do they only do so when it's convenient? I think that's maybe the way to frame it.
Excellent. Nima, do you want to comment on that, or do you take the next question, next clarification question? Because you've mentioned a number of pieces of evidence in your discussion, and this is also something that in the media coverage often gets lost. And the question of nuance, of complexity of the situation that is often used as a narrative to question whether or not we can qualify the situation on the ground as an unlawful occupation, as genocide, as apartheid. So what is your take on this decredibilization of many of the sources of the evidence that we have in the media?
So in terms of the question of complexity, obviously when it's invoked in this context, it's basically an abdication of intellectual responsibility. It's an abdication of judicial responsibility. So there were a few judges in the ICJ case of the legality of the occupation who invoked complexity, and then they started explaining what they think would, be more nuanced, and then their so-called nuanced position lacks complexity. So an example of this is an opinion that is added to the main ruling by the court by 3 judges, Tomka, Abraham, and Oresco, and they say something like, well, Israel accepted the roadmap. So that was 2004, the Ariel Sharon government, without telling the reader that Israel had 14 reservations that made the so-called acceptance of the roadmap basically null and void. So that's not complexity. That's simply a rhetorical move in order to avoid the judges themselves being clear morally and legally, and then the political consequences that supposedly would follow from that clarity of the position. I was listening to kind of a famous lawyer the other day in one of his lectures online, and he was asked about violations of law by Israel in Gaza and Lebanon, southern Lebanon, and he was like, I'm not on the ground, but it looks pretty bad. No shit, Sherlock. No, you are not on the ground in Russia and Ukraine, and still you have very clear denunciations of Putin and the Russian government and the Russian aggression against Ukraine. When it comes to the question of, for example, the binding nature of the decision, the British government said the same thing about the advisory opinion when it comes to Chagos case. And now there's an agreement between, of course, I think that the agreement is a bit defective, but there's an agreement in which supposedly the British government recognizes the case and cedes control of some of the islands.
Could you explain that case a little bit for the audience, those who are not familiar with how parallel maybe this situation is?
Again, so in the 1960s, when Mauritius won its independence, the United Kingdom decided that they will keep a slice of Mauritius to themselves, which is called in the Indian Ocean, which is an archipelago of islands. And then they leased it to the United States within the Cold War kind of development to use as a military base. And in that development, they also expelled the Chagosians from their territory, and most of them went to Mauritius. So the decision by the ICJ said that the United Kingdom needs to decolonize. It needs to give the Chagos Islands back to Mauritius. Now, one of the interesting, and that was something that actually some of the lawyers for the state of Palestine in the ICJ case on the legality of occupation built upon, because it's also a question of decolonization, and yet the words decolonization were not used when it comes to Palestine. They used the denial of self-determination, the acquisition of territory by force, etc. So the point is, it becomes binding if the state accepts the obligations under international law as interpreted by the authoritative source of international law, which is the Court of Justice. In the case of the genocide cases, there are cases where the court issues orders. So orders, in this sense, are binding. But you saw that Israel, despite this binding nature of these cases, did not comply with them. In the advisory opinion, what are the obligations that follow, the court says, on Israel and the United Nations, on third states, from international law as we understand it and as we interpret it. So they are binding in this sense. They are not binding in the sense that it's not an order to the parties before the court, because it was requested by the General Assembly as the UN is asking the court, tell us what the law says. And then the court said, Israel has to dismantle the settlements. Israel needs to withdraw as rapidly as possible, which is, again, a similar formulation to the one that was in the Chagos case. Can I say something about the apartheid thing?
Of course, we can start that. But just, Sergei, you're taking notes. Is that to react on any of these points before we go to the apartheid discussion? No, okay, excellent. Well then, let's begin.
So, no, I mean, we are in agreement. Obviously, I didn't go into detail. So what the court said is that Israel violates Article 3 from the Convention on the Elimination of All Forms of Racial Discrimination. And then they quote the article which says that it prohibits racial discrimination, racial segregation, and apartheid. And then leave it to you, a reader, to know which judge thought it's racial segregation, as in Jim Crow, or apartheid. Now, there are 4 judges, including the president of the court, who in separate opinions said, of course it's apartheid. If you compare to South Africa, it's apartheid. If you judge it by the Convention of the Prohibition of Apartheid, it is an apartheid. And those of us who are, want more references, we have 500 pages by Human Rights Watch and Amnesty International that detail why it's an apartheid and why it's a violation of the convention, and why many Israelis themselves said that it's an apartheid. But we don't have a disagreement.
No, so it was only on that formulation of the opinion that I tried to stir
to find some debate here.
No, but exactly, the clarity is there, as I said, for 20 years.
Excellent. Well then, shall we maybe move to the question of what does that mean for us? So we've discussed what these third-party obligations mean for the Netherlands. 2 different elements, the third-party obligations arising out of the allegations of genocide and the other relating to occupation. But now, what does that mean for us, the EU citizens, possibly employees, employers, some people at university? Does anybody would like to react?
Yeah, it's working. So I'd start by saying that international law is too important to leave it to international lawyers. And compliance with international law is also too important to just vest all hope in the representatives of this professional caste, right? It is essentially the duty, moral duty of every citizen to act on the knowledge. First of all, to make sure that you are informed, to read news, check, double, triple check all the information that you are getting, counter and be critical about any easy narratives that you are being fed. Be principled. If you support accountability in one situation, please be so kind to also support accountability in all other situations. Otherwise, you are not really for accountability. You are just maybe invested in some sectarian agenda, but then do not present yourself as an advocate of justice for all. It will be justice for some. Essentially, justice for some is injustice. So as citizens who are mindful of the current political realities, who are aware of the difficulties of fighting for compliance with international law, I think you can do a lot by mobilizing in the framework that currently exists. Invest in grassroots initiatives. Make sure that you talk to people who think alike, but also to people who think differently, because this dialogue has to be happening. It is very difficult. It is very confronting. I know from my experience when trying to talk to my compatriots about the conflict in Ukraine and all the atrocities that happened there. It's not easy, but we owe it to ourselves. It is our duty to reach out rather than go along in this atomized society where everyone is for their own and is just afraid to engage. And then grassroots initiatives are extremely important. Numbers really matter. Taking issues to the street is one meaningful way to raise awareness and also to show to your government that you disagree with certain policies. And yes, in 9 cases out of 10, this would not result in anything constructive, but in one case, maybe it will lead to a change of policy, especially if such protests are happening regularly. One event that is very remarkable happened last Friday. I read the news that Amsterdam City Council filed a petition with the Dutch government demanding to clarify its position on compliance with international law in the context of Gaza. So now the Dutch government has to somehow process that petition. The more such petitions, the more calls to your MPs, to your members of parliament, or to your local representatives, the better. What is most important is that we all fight this feeling of powerlessness, this lack of agency, because that's what all authoritarians and autocrats are always aiming for. I know this again from experience. That's how the civil society in Russia has been completely destroyed or driven underground. Resist in the way you can. Peaceful resistance can do a long way. Peaceful resistance that is not peaceful is also one of my favorite topics, but we don't need to discuss it now.
I agree with that. I think it's important, there is, in different spaces of life and engagement, we tend sometimes unreflectively to reify the institutions we are part of. So, in the university is all of us, is the students and the staff, and it's not only management. So if you think of the university as only management, then you are reifying the institution and depriving yourself of the agency of trying to change the institution in ways that are more kind of optimal. The same thing with states or law. So the enforcement, as Sergei just said, cannot be simply a question of waiting for the states to enforce, as if the states is something separate from us. We inhabit the states. We are the states. We are the electors. We are members of parties. We are members of unions. We are members of student movements, etc., etc. So we need to take these positive legal developments and use them. And to the extent that they fall short of the demand of justice, we mobilize to bridge the gap between law and justice. I heard, there are so many cynical kind of views about law, specifically from non-lawyers. And then there's idealization of law by lawyers, but I don't think we should avoid both. And one of the cynical views that I saw after the July advisory opinion was that the judges said what we already know. Now, that's nonsense because it misunderstands the idea of law as an intervention in a field of political contestation. This is not rehashing something you already know. This is a vindication of your position as a student who was dismissed when they said, apartheid or genocide or any other criticism of Israel. This is a vindication of the anti-war movement and all the demonstrations that many of us were being marching to, and they were defamed. These, as Sergei said, depend on the particular spaces in which you work and inhabit. So an example that I used in a talk for the National Education Union in Britain. So in Britain, there's something called Prevent. And I guess there's something similar in other places, which is, kind of counter-radicalization legislation, which is basically religious profiling, identifying a particular religious doctrine as if it leads to radicalization and then to, terrorism or to joining ISIS or what have you. Now, Prevent in the UK means that the whole social structure becomes people spying on each other. Because prevent means that I have a duty. If I see signs of radicalization in one of my students, I need to report them. If a nurse or a doctor sees signs of radicalization, there were cases of teachers reporting a 6-year-old in school because instead of terrorists, in their essay they wrote terrorist. We have a terrorist in our home rather than terrorists. It's absurd, but this is what's happening. And it of course, means there's a lot of distrust in the social body instead of solidarity with each other against the authoritarian trends that we have. An example I gave to the National Education Unit said, if you fear being accused of radicalization, why don't you assign your students the ICJ application by the South Africa, which is on the International Court of Justice website? No one will accuse you of radicalizing the students with that kind of link. It's as mainstream as it gets, right? You're not sending them to some kind of random website with shady materials. So there are different ways in which you can assign these materials that says apartheid, colonialism, genocide, etc., as South Africa did, or even the ICJ cases where there is, in the July case, kind of a history, basically, of the violations that Israel have inflicted on the Palestinians. And then you can see why the long-standing impunity emboldened Israel not only to commit long-term apartheid, which is a crime against humanity, but also genocide.
Indeed, and following up on that, that goes to the negligence I've been talking about, the looking away, and that is very true for that society. That's governments, that's citizens, that's us. So I very much agree with that we should engage. I mean, there are peace movements here in the Netherlands that are very, very active. Talk with each other and talk with each other in the institutional context. I mean, but also make sure that you engage politically and talk to your parliamentarians and to the government. I mean, there are a lot of measures that can be taken, that should be taken, to put pressure on those that violate international law. And really, there's so much that needs to be done that I think we all need to engage much more. And that's also where we have to fight the cynicism, because the instruments are there.
Thank you so much for this hopeful note also. We'll have to leave it at that for the discussion right now so that we have some time for audience questions. And I'd like to ask whether it's... is there another microphone? So that that one? Yes, exactly. Let's collect a couple of questions. If you can, please tell us to whom you address that question, and please be reminded of the spirit of and the focus of this panel, and try to keep it short.
Yes, thank you all for your presentations. It was really interesting. What I missed in the presentation was the time frame that the ICJ has ruled, that Israel should end its occupation by September. Could you maybe say on that matter? And the second question is, as we are witnessing that the space for activism and freedom, especially within universities, how it has been shrinking in the past years, and the crackdown on student movements and other pro-Palestinian activists, do you have perhaps a positive example of holding officials accountable for groups that won? And what can we do about that? Thank you very much.
My question is addressed to Janne about the third state's obligations. Hi. So our government has been saying that they are doing what they can. They have been having really tough conversations with the Israeli government. But in terms of legal obligations, You spoke about that there are obligations for third parties to take certain measures. Now, what are those measures, and how can we hold our government accountable in a way that we can say, your talks are not enough, it should be more? Because who decides whether the measures that they are taking are enough or not? And the other thing is, you said that by looking away, our government is complicit, and I was wondering whether you mean that in a legal way, and if so, could you maybe elaborate on that in how they are complicit? Thank you. One more? Three questions.
My question is for Dr. Sultani. It's a slightly long question, so please bear with me. I'm not sure about international law, but I believe law in general works on the basis of precedents, which means if there is a case before with similar facts and circumstances, it can be relied upon to come to similar decisions in the future. You mentioned several cases, including in Bosnia and Myanmar, which have been accepted as genocides by Western states. You also mentioned that the scale of destruction and casualties in Gaza are greater as compared to these previous cases of genocides. There is also sufficient evidence of genocidal intent on record. So what seems to be the issue with the deliverance of justice in the case of Israel's ongoing genocide in Gaza?
Perfect, I think. Yeah, who would like to start?
I have a full list of points to address. Okay. Bear with me. Thank you so much for the question. The timeline, maybe just one thing. I think I mentioned September 2025, and so action is needed. And that maybe goes to your question. I didn't hear your name, but thanks so much for that question. Yes, who decides? Well, it's of course hard to be present at the so-called tough conversations, but there is more we can do. If you look at third-party obligations, there are, for instance, sanctions that could target economic activities in the West Bank or in the occupied territories broadly. Now the Dutch government talks about a policy of discouragement. Discouragement is not preventing collaboration with settlers and collaboration in a way that you support the settler economy. So there, for instance, I see discouragement not as in full fulfillment with a third state obligation. And the same one could say, one could target individual settlers. Maybe Sergei wants to say more about that. But also in the European context, there is, of course, the whole visa policy issue. And you could target individuals much more clearly. And I mean, ministers themselves are expansionist settlers. There are more that you can target with those sanctions. So, same, to be honest, with my remark, and then we go on, of course, with respect to Wilders. Today, what I saw as the only official response of the minister to so-called plans by Wilders to visit the settlements and settlers was saying that it is hacks for the people in Dutch, so that means contrary to Dutch policy. I would say when you look at third state obligations, you need to prevent Wilders to go. It would be a violation of the Dutch government. If you look at the reasonings, the logic of state responsibility, you could argue that Wilders, being the political leader of the main party of the coalition, has a sort of element of governmental authority. And when he goes there, the Dutch state is responsible. So I would say there is more we can do. The Dutch government can do more, and to engage with our previous discussion, it's us who are part of political discussions who can bring this to the debate.
There was a question about the timeline. So what the ICJ in its July advisory opinion said that Israel needs to withdraw as rapidly as possible, which is what also was said in the Chagos case. Now, it left the implementation of its operative part to the UN and its agency and other parties. And indeed, the UN General Assembly, I think Miriam in the beginning mentioned it, issued or agreed on a resolution that said as rapidly as possible means 12 months. Now, whether that will be implemented by Israel or not, we can be skeptical about that, obviously, specifically given the fact that there are powerful states that either abstained or opposed that UN General Assembly resolution. But this is where we stand in terms of at least setting the standard for what is a violation of international law by Israel. In terms of the question of what is international law and does it follow precedent, I would say different things. One, first of all, we here, as far as our moral and political judgment, whether this is a genocide or not, we don't need to wait for courts. We have independent judgment, we read, we educate ourselves, we see the evidence, and we decide for ourselves. There is genocide in genocide studies, which is not the kind of legal, as a legal category, as a sociological and historical concept. For example, there are colonial cases of genocide prior to the 1948 convention. And one of the interesting things about the ICJ intervention by South Africa is that it ignited some of these debates about what is the legal conception of genocide, what does it miss, and how does it relate to other historical. So when Germany said they are going to intervene in support of Israel, immediately Namibia said, wait, didn't you commit genocide against us in 1905 and 1908? The fact that the Genocide Convention did not exist at the time doesn't mean that I can't call it a genocide. And in that literature as well, there's a lot of criticism of the ICJ case and the Bosnian cases, that they fall short of recognizing the systematic nature of killing and destruction. So in a way, the ICJ now is at the crossroads because there are two major cases. One of them is the Myanmar against the Rohingya, or Gambia against Myanmar with respect to the genocide against the Rohingya. And then the South Africa case against Israel with respect to the genocide against the Palestinians in Gaza. The 6 states, including the Netherlands that I mentioned, who intervened in the Gambia case, they didn't know that South Africa is going to bring this case in December. Now they might be trying to, backpedal their arguments. But their arguments was a valid one, which is you can't set the threshold too high, as the court did in the 2 Bosnia cases in 2005 and 2007 and 2015. Otherwise, there will be no cases of genocide from a legal perspective in the ICJ. And then the whole Genocide Convention becomes without any practical utility. It becomes, as someone said, a historical commentary on the Holocaust, because the only case that is kind of modeled after the genocide is modeled after in the convention is the Holocaust. So with respect to the question of precedent, it might be the case that the court will follow what it decided. But what we teach our students in law school is that previous cases can be distinguished from other cases. So good lawyers always try to find what is the fundamental differences that might require a different judgment. And every case, obviously, has its own kind of particularities. What's interesting, I think, about the Gaza case, it's the first colonial genocide, because the Bosnian cases were in Europe, and the Holocaust was also in Europe. And then this is a case of a Western-supported genocide against a native population by a colonial movement. The ICJ itself, usually the highest court in the system can itself revise its judgment, and these judges change over time, so they can possibly, if they wanted. And this is one way in which we can help, actually, because the more this is an increasing consensus in in academia and in popular culture that this is a genocide, you open up the political space for more judges to admit the fact that also legally this is a. Now, we need also to understand that law is not immutable. So there are two ways to change law. Either you change the Genocide Convention, so and the definition of the genocide in it. So that requires a quasi-legislative process, or you can change law through interpretation. So the judges themselves, they tell us what the law is through interpretation, and that interpretation can change either explicitly or through the way they apply legal standards, which are usually abstract to particular cases. Finally, final thing I would say that we need to distinguish between two functions of the Genocide Convention and the way and the role that the court played or could have played. One is the preventive function, and the other will be punishment or determination that a genocide was committed. For the second part, unfortunately, it takes many years for that to happen. So that's why it was important to have what we call provisional measures, which are orders right now, right here, to try to prevent genocide. Unfortunately, because of the brazen Western support for Israel, to the extent that they are willing to undermine the whole post-World War II legal order, these orders were not effective.
Okay, I see it's already 9:30, but there are probably still many questions. So let's try to keep the questions short and the answers. I saw also here before a couple of hands and then in the middle.
Thank you. Very briefly, the three statements were, I think, very realistic. But there was maybe one minor point raised by Janne Nijman, and it was in her final sentence, referring to the two-state solution. Do you really think that's a realistic way to solve this conflict? Or is referring to the two-state solution at best a fantasy and at worst a fig leaf?
Thank you so much for your talks. My question kind of relates to that as well, because I think you mentioned the two-state solution together with recognizing Palestine. So I wanted to ask about the legal implications. Do they change if the ICC, the ICJ, or third countries recognize a country?
One more question?
Yeah, it's kind of a follow-up question to your point. So would maybe the recognition of Palestine as a state legitimize Israel's claims for self-defense, or other criteria would apply in order for those considerations to be completely rendered redundant?
So the first question regarding the two-state solution. I think your skepticism is something we fought with when we were dealing with that advice. And we had many, many interviews of all of so many stakeholders, among which the highest in the UN. Excuse me. And the message was very clear. It's basically that. And yet, alternatives aren't there either. So I would say it's neither a fantasy nor a fig leaf. It's what ultimately made the council say that it can't be business as usual. So that the advice really was that where it comes to the Dutch foreign policy, that it needed to change its course by seeing the recognition, and that goes to the other question, recognition of the state of Palestine not as something that should happen together with a peace deal or after a peace deal, but really should be done now and as soon as possible to keep the state and then the two-state solution alive, and that the Netherlands should actually actively pursue that course and build coalitions. So I understand what you're coming from, and yet that's ultimately why we advised for a totally new course to keep it alive.
So, with respect to the question of two states, I mean, very briefly, I guess the insistence on, by the EU and some of the European governments on it sometimes feels like they are not willing to recognize the injustice of Zionism and the fact that Zionism is not willing to grant equality and freedom to the Palestinians. So the situation currently is that the EU keeps telling us that Israel is a democratic oasis, even though it does not grant equality to 20% of the population who are non-Jewish. The Constitution simply glaringly omits equality for a good reason, because you can't reconcile equality with Jewish supremacy. So that's the current state. So even if there's another state and then you've got two states, we still have to face the problem of what Amnesty in its apartheid report called apartheid over all the Palestinians since 1948. Human Rights Watch had a different formulation which said institutionalized racial discrimination since 1948 and then apartheid since 1967. Whatever it is, it's obviously there's a systematic inequality in Israel. And with the increasing right-wing trend in Israel, it becomes, as many of us legal scholars call the nation-state basic law in 2018, a constitutionalization of Jewish supremacy and apartheid, meaning that it's entrenched in higher law. That is, it's not easy to change. So the second issue, which is the question of self-defense, if it's recognized as a state. Well, as I said, the formulation that the ICJ chose was, if a state effectively controls another state. So whether that is considered as a state or not a state, I don't think it's immaterial, because it will be occupied nevertheless. And as an occupied territory, then it's not an external attack from within a territory that's not controlled by the occupying state.
Yeah, thanks for all these questions. I'm afraid I am with Nimer on this issue of a fig leaf. We just had an exchange before this panel, and I asked him a question whether a two-state solution is a dead horse which is being pulled at, and I think that's also a good metaphor to describe it. I think two-state solution would have worked had Israel respected the territorial integrity, sovereign equality of the state of Palestine, rather than using it as a cover-up for creeping annexation and for imposing the brutal occupation regime, where basically Palestinians are deprived of their fundamental rights, where there is no equality between the citizens of Israel and Palestinians, and also Palestinian citizens of the State of Israel. In an ideal world, we would perhaps have had a one-state solution where all citizens would have equal rights, a state free from discrimination, free from apartheid. But unfortunately, the ideology of Zionism precludes that, because that would have affected the Jewishness of that state. The Jewish majority would have been undermined. So that's the real ideological obstacle to this unicorn solution of one state. And we're stuck with this paradigm, which unfortunately in these circumstances cannot work, because Israel does not seem to want to make it happen, and the states up to whom it could be to maybe discipline Israel and influence Israel so that two-state solution could be realized, they are not willing to enforce international law. So it's an impasse in a way.
Thank you so much. So we have to vacate the building at 10, I understand. Is there still room for one or two questions? Sure. Excellent. Okay, then I see Andrea and Joel.
Thank you very much. For anyone who wants to respond to this, what do you think changes with the election of Trump? What is the outlook of this new government in the US for this situation?
What worse can happen?
Thank you. Thank you for all your presentations. Just to pick up on the question that was asked earlier about the legal obligations of third states and complicity, I was wondering specifically, Janne, if you could expand a little bit on the F-35 program, the Netherlands' policy with respect to the export of military goods that it's still trying to do via the US. To what extent is this not in compliance, in breach of this obligation not to render aid or assistance? Because, of course, it's a slightly different case. This pertains to the situation after the 7th of October. And this advisory opinion is, of course, about what happened, has been ongoing for decades. But, of course, there is an overlap. So I was wondering if you could expand a little bit on that. Thank you.
I see one last question there in the back. If it is a short question, we'll take it.
Okay, I'm going to try to make it short. So I was wondering what will be the rippling effect of this in the sense that will this set the precedent for other states to, if the rule of law, basically of international law, is not is disrespected in this way, what will the effects of this be, and could other countries be encouraged because of the deterrence effect of the law to abide more to these rulings?
Thanks. All fascinating questions. I think I will pick a question on the effects of the election of Trump. What will be the outcome? And also the rippling effects on the international law. Well, unfortunately, I don't have any positive predictions for you. Of course, Trump election would basically result in a policy of double standards, hypocrisy that the Biden administration has been engaging in, but only on steroids, essentially. The Trump administration, number 2, will be brazenly and openly attacking and dismantling all still surviving international rule of law institutions. All international courts will be under attack. And just like mainstream media, he would be confusing ICJ with ICC. He would be just, blaming courts for all of his troubles. I think the administration of Trump will be building on its previous experience, because in the first administration it had 2 real enemies of the ICC, for example, Mike Pompeo and John Bolton, whose task was really to discredit the International Criminal Court, to diminish its authority. They're responsible for imposing sanctions on the members of the office of the prosecutor, like personal sanctions, which were quite racist as well, because only the two members of the Office of the Prosecutor from Africa were sanctioned, but not the Deputy Prosecutor from Canada. Don't ask me why. So we will see much more of that. But maybe there is also a silver lining, because Trump is not particularly intelligent, nor can his advisors be expected to be very intelligent. Maybe they will not be doing it in a very smart way, but in an extremely aggressive, brutal way, acting really like thugs, like mafia bosses. And then maybe that would create a counteraction by other states parties to the International Criminal Court or to other members of the United Nations, who will say, well, this we will not allow. This is completely against all the basic rules of decorum, of respect for the judiciary. Maybe we will see finally some resistance to that. But yeah, the rippling effects of disrespect for international law, they very quickly become endemic and systemic, because autocratic rulers, they're very good at learning lessons from each other. Like if you look at what the Putin government has been doing in relation to the International Criminal Court, he did not invent all this, like starting criminal cases against the ICC judges, putting them on the search list, as if judges of the ICC want to have a holiday in Kazan or in Ufa somewhere. It's like they would ever come to Russia. No, but they're doing it, and they learned it all from their American friends and partners. So now Trump, who is a big fan of Putin, will also be looking up to Putin and trying to implement all the tricks that Putin's regime has been using. So they are really learning from each other. And I think since these guys are such a nice company and big friends, maybe finally liberal Democrats, freedom lovers could also unite and make the new international. I don't know.
I hesitate to add more to the bleak picture. But quickly, I mean, you know, obviously the attack on UNRWA started during Trump, as you remember. The kind of recognition of the annexation of the Golan Heights also started under Trump. Effectively, the annexation of East Jerusalem also was kind of, by the move of the embassy, was started by Trump. And in two of these cases, the Biden administration was a continuity with Trump. So they did not move the embassy back, did not say anything about the annexation in the Golan Heights. There was also the recognition of Moroccan sovereignty on the Western Sahara as well at the same time. So some Israeli journalists were saying, since the election of Trump, that this might lead to the recognition of annexation of at least Area C in the West Bank, and the annexation of parts of the territory of Gaza, at least, by the Israelis. So Trump might try to do that. Now, the UNRWA thing is, in particular, is important because what we are talking about here, and we need to remember this because much of the discourse on UNRWA is kind of a post-October 7 discourse that Israel tried to invoke, you know, terrorism or security. But in fact, given the fact that it attacked before, the main issue is the continuity, the intergenerational continuity of the status of refugee, as recognized by a UN agency, in this case, UNRWA. Israel, by dismantling UNRWA, in addition to the humanitarian consequences, obviously, but the main issue is abolishing the status of refugee. And if you take into account that 2/3 of the Palestinians are refugees, then this is an attempt to liquidate the question of Palestine. What's happening in Gaza, and if Israel gets away with it, with the support of the US, Germany, etc., is frightening because it's a model for how to treat surplus populations, unwanted populations. Israel tried to manage the Palestinians generally, and in Gaza in particular, for a long time in different ways. When they did this engagement, so-called disengagement plan, the Ariel Sharon government, the assistant to the chief of staff of Ariel Sharon said that we are putting them on a diet. They are not starving, they are above starving, but the point is to manage them and control them. The different highly disproportionate attacks on Gaza every few years were called mowing the lawn. Basically, colonial wars to guarantee a colonial peace of an apartheid situation. And when that did not work, genocide was the answer. So will it be copied by other cases? Now, we need also to remember, and I will end with that, and the reason why I said it's a litmus test rather than an exception, because we have other cases in which the weak is being crushed by the strong and international law is not effective. So the war in Yemen has been going on for years and years, and international law has been as ineffective. The peculiarity of the question of Palestine is that a long-standing, fundamental, grave injustice that shows that as in the millions in the Thucydides book on the Peloponnesian War around 400 BC, or the Athenians told the millions, so the Athenians were the empire and the millions were a small and a weak nation, they told them rights are in question between equals in power, while the strong do what they can and the weak suffer what they must. So this is the vision that Trump and Israel in its current form are trying to bring, which is might makes right. And it's a terrifying vision for the world. And we need to resist it by any means we can.
Thank you. I'm glad you indeed mentioned also other conflicts with sometimes millions of victims, like Sudan, and which is also important to keep in mind. But we have to go back to this horrific situation with Nima. You started your talk with incredible numbers. The human suffering is just incomprehensible. So I want to pick up, before I answer the question, on the comments on the two-state solution, where we ended, because I don't think we disagree at all. It was an attempt on my part to say we need so much more pressure, right? We need so much more pressure and diplomacy. So the question with respect to complicity, a very important one. I think you related, I think it was Joel, right? Yeah. Related to the F-35. You could talk about it in a more general context, or with respect to other obligations as well, but you referred to the permits for arms. Well, it seems on the basis of the court cases that it makes sense to withdraw permits of arms, right? And one could make an exception for sort of defense systems, but clearly there needs to be a withdrawal of permits for arms that are used with violating international humanitarian law, international human rights law. There was another question, but you have to remind me, or you want to close?
I think, unfortunately, we will have to come to a close now.
Okay.
I think you actually covered.
Yeah,
we covered most.
Okay.
Yeah, the questions as far as I'm concerned. Thank you so much. Please join me in welcoming and thanking. And also the engagement of the audience was great. Thank you so much. Get home safely, and see you at the next SPOW event. Thanks.